So stay tuned. We'll give you another perspective on that, and all the little questions that we just brought up that we didn't know the answer to. We'll get those answers to you in the next episode. So, all right, let's get this other little clip from Nancy up.
On Wednesday, attorneys for Idaho murder suspect Bryan Kohberger filed a motion to dismiss his indictment on several grounds, including bias and lack of evidence.
Kohberger's team raised 24 specific issues with the indictment, although none of them have been released as the motion was filed under seal. This comes on the same day he waived his right to a speedy trial.
And here to react is Fox Nation host Nancy Grace. Nancy, what's your take on this?
Well, I think that it's much ado about nothing. Now, we've heard that there are 24 secret claims. That sounds very mysterious. It's not mysterious. This is what happened. The defense, of course, is trying to attack the grand jury indictment. They're claiming the grand jurors were biased, that they had the wrong standard of proof, that there was insufficient evidence, blah, blah, blah. None of that is going to amount to a hill of beans. Why? Because the defendant doesn't have the same rights in a grand jury proceeding as they do at a petit or smaller jury trial of 12. At a grand jury proceeding, it's very simply a charging tool. The defendant's not there, his lawyer's not there, there's no cross-examination. When they say illegal evidence or inadmissible, they're probably talking about hearsay. It's gone all the way to the U.S. Supreme Court. Hearsay is allowed at a grand jury proceeding. It's charged. They have all those rights at the petit trial or the jury of 12. So this is much ado about nothing, and it's secret only because the defense asked and the judge agreed to put it under seal. It simply hasn't been made public yet. I'm not worried about that at all. I'm more worried about the defense claiming that they have been denied their constitutional rights because they had to waive their speedy trial demand because the defense lawyer wasn't ready. Boo-hoo. Doesn't matter. If she's not ready, she's not ready, and she can't go to trial. That's on her, not on the state.
Well, Nancy, you've got a fascinating new special, Bryan.
Pause it here. Gosh, I think she covered almost every angle I thought of on that. And one thing that I really didn't understand is that it's a charging tool and that hearsay is allowed. Kind of like the hearsay that people are doing in these YouTube videos. And it's even been brought to Supreme Court to show that it
is allowed. Because here's the thing. It isn't a jury. It isn't a trial. It's a hearing. It's a grand jury hearing. And the grand jury is only looking for, do we feel there's enough evidence? And it can be completely circumstantial. It doesn't have to be real evidence that you present. Do we think there's enough to charge this person with these crimes? And they decided yes. That's the end of the story. Now, for Bryan Kohberger, if he does, I get why his team is filing a motion to dismiss, because that's just what you do. You're going to file a motion to dismiss because of this. He's trying to get off on a technicality. Will he? I doubt it, because then what happened was they arrested him based on this grand jury indictment, and then they really got DNA that they really matched to him. So a lot of the things in his motion to dismiss are things like the grand jury was biased, or they received evidence that he doesn't like the fact that the DNA went through the genealogy in order to find out who he was. But okay, that was just a means to an end also, because even after they did that, then he was arrested, then they swabbed his cheek, and then they got the actual connection. So it's not going to get thrown out on that. His time to defend himself is during his trial. And to her point that his attorney wasn't ready, yeah, boo-hoo, that's on them. Because you should be ready. Why aren't you ready? Right? If you need more time, you ask for a continuance. I don't know that he needed to necessarily waive his right to a speedy trial, but I think that that was their intent. They don't want this thing going too fast to trial. So in the defenses, the longer he goes out, the more people are going to start to forget about it's in his best interest to waive his right to a speedy trial. I don't feel sorry for him for that at all.
most people would want more time to defend themselves, and for all the reasons you just said.
Right.
Witnesses.
He's grasping at straws.
Yeah, I agreed.